Good afternoon, everyone. Happy Friday. This is John Porta. I'm a principal in the Long Island office of Jackson Lewis. And I'm excited to be presenting to you today for our Lunch and Learn. And I'm not going to disappoint. We do have a little homework for everyone at the end of this to sort of wrap up what we learned today. But for those of you who don't know Jackson Lewis, I'm going to say for 30 seconds I'm going to talk about us. Jackson Lewis is a national workplace law firm. We have 57 offices, approximately 800 attorneys. We're everywhere, and all we do is workplace law, and all we do is represent management. Today's topic is relating to proposed EEOC enforcement guidance on national origin discrimination. I know a couple weeks ago, my partner Anna Shields talked about additional guidance that the EEOC has issued with respect to leaves as an accommodation. The EEOC is pumping out a lot of enforcement guidance right now. I think we could relate that to the end of the Obama administration. We're going to see a lot of activity at the EEOC as it wraps up the Obama administration. And these are actually really helpful guidance pointers for all of us. And what we get from this is it gives us a perspective into how the EEOC will investigate charges of discrimination that are alleging national origin discrimination. And it gives us a sense as to we're going to have an idea on how these investigations are going to go. But not only does it deal with, and this guidance help us in giving us perspective on how the EEOC, which is the federal agency that enforces the federal civil rights statutes, how the EEOC, it's not going to give us information. It's not only going to give us information as to how the EEOC is going to be looking at these claims, but it also really gives us insight into best practices. Because again, although EEOC guidance isn't something that the courts have to follow, a lot of courts, especially in New York, do give deference to the EEOC's interpretation of these statutes. So national origin discrimination in Title VII, just a brief overview. Title VII is a federal civil rights statute, Federal Civil Rights Act of 1964. That's Martin Luther King's dream. That's the employment legislation that restricts discrimination in the workplace. And under federal law, Title VII protects job applicants and employees from employment discrimination based upon their race, color, religion, sex, and national origin, and of course, retaliation. Remember, this is federal law. We in New York, I'm pretty sure that almost everyone on the call is from New York. We know that we have the New York State Human Rights Law, which has a much broader group of protected categories. And especially New York City is even broader than New York State if you have operations in New York City. So when we talk about Title VII, we do know that there are additional protected characteristics. Again, one important thing when we look at sex, although sexual orientation is not included in the protected categories, the EEOC recently issued guidelines explaining that it's going to enforce discrimination, sexual orientation discrimination, because they're taking that a look and they're sort of having that fall under sex discrimination. When you look at national origin, so the focus of today is really national origin, so none of the other protected categories. And what national origin is national origin means the country where you were born or the country where your ancestors came from. So it includes your physical, cultural, or linguistic characteristics. We as employers know, and it's not just the country you're born in, right? It's a much broader thing when you talk about national origin. It's not only the country you're born or the country your ancestors are born in, but it's also ancestors were born in, but it's also the your ethnicity, how you identify yourself. So we'll use me as an example. My mother was born in southern Italy. My father was born in New Jersey. I could hear the chuckling on the other side. I was born in New Jersey. My national origin, what's my national origin? My national origin is American, right? I also have a national origin history of, Italy, but, if you look at my ethnicity, if you look at, the fact that my mother makes me go to her house every Sunday for a macaroni dinner and that she calls me incessantly 25 times a day, that's my Italian ethnicity, that's my heritage. That also falls under the definition of national origin. We can't treat people differently or discriminate against them because of their national origin. the EEOC has issued this guidelines because the last time that they really addressed national origin discrimination was in 2002. A lot has happened since 2002. I'm shocked that it's so long ago, but it is a long time ago. So that was the last time that they really addressed national origin discrimination in the United States, and a lot of things has happened since then. Currently, 11% of all the charges filed with the EEOC allege national origin discrimination. So it is a big portion of the charges and the complaints filed in the United States today. And another, sort of it's not just national origin as an issue. What we're seeing now is, a couple of different protected categories, right? So I put an example here, and it says, for example, discrimination against people with origins in the Middle East may be motivated by race, national origin, race Arab, national origin, i.e. from Jordan, or their religion, Islam. So right now we're seeing the national origin piece, and what the EEOC is trying to explain to us is that it's all intertwined, right? And given current events, two big events right now, in terms of national origin and why this is sort of on the national forefront, which has probably prompted this. One, we've just seen the Supreme Court yesterday. They were unable to decide. It was a deadlock, but basically they shot down and denied President Obama's executive order, which was the pathway to citizenship, which would have legalized or provided an avenue for citizenship for over 10 million Americans, undocumented Americans. So we're seeing this as a big thing right now. In addition, we're also seeing, given the state of the world, and even after 2002 was right after 9/11, but we're also seeing a lot of claims filed by Arab Muslim Americans, given backlash, in terms of stereotypes and things about Arabs and individuals from the Middle East. So a lot of that 11% is from, sort of those protected groups. Currently, the biggest influx of immigrants, so we're seeing even more and more influx of immigrants, right? And the biggest, the countries that we're seeing these immigrants come from really is Latin America and Asia. So with those immigrants coming into the United States, you're seeing an even more diversified workforce that we saw in 2002. So now that we're seeing a much more diverse workforce, the EEOC thought now's the time to really remind everyone of what their obligations are and how to avoid potential claims of discrimination. This is just definitions of national origin discrimination taken from the EEOC guidance. Place of origin, these are all forms of national origin, right? It could be the country that you're born in, and it could be a former country that no longer exists, like Yugoslavia. It could also be a geographic region, right? Somebody can have a national origin claim if they're from Kurdistan or Acadia. Ethnicity. And these are sort of the definitions. These are the definitions from the guidance. A group of people who share a common language, culture, ancestry, race, and or other social characteristics. For example, Hispanics, Arabs, and Roma. These are national origin groups or ethnicity groups. The important thing that these regulations really focus on, that this guidance really focuses on, is that national origin overlaps significantly with race, color, or religious discrimination. More often than not, somebody's national origin is often associated with their race and often associated with their religion. So again, what the EEOC is seeing and how they're going to investigate these claims, it's likely that a national origin claim goes hand in hand with a race and or a religious discrimination claim. Just for everyone's sort of reference, where we talked about national origin means sort of the country where you're born, your physical, cultural, linguistic characteristics, or ethnicity. Race is a little bit different. Race refers to a person's physical characteristics, most typically skin color, whereas national origin, on the other hand, refers to where a person was from or where that person's ancestors are from. But again, a lot of times they're intermixed, but they do have there are specific differences, and they are different. And like we saw, 10.6, I rounded it up to 11, charges filed with the EEOC alleging national origin discrimination. So this enforcement guidance was published on June 2nd, just recently, and there's a 1-month public input period. We're going through that right now. The public input period is basically members of the public. If they have any opposition or any questions or any thoughts, there's a 1-month period of time for everyone to submit their input. And the purpose of this guidance is intended to serve as a reference for EEOC staff investigating charges, lawyers bringing litigation, employers, and employees. This is the EEOC's interpretation of the law. Here's some key differences, and I think what you'll see is, we're not going to go over the 2002 guidelines, but it's interesting to note the difference from 2002 to the present. These guidelines provide really robust, concrete examples of national origin discrimination. I recommend everyone going to the website. I'm going to talk through one or two examples today, but going to the EEOC website and pulling up this proposed guidance. If you pull it up after July 1st, it no longer will be proposed, but it'll actually be the guidance. They have some really great examples, and I think it helps in a lot of workplace situations to the extent that a situation comes up at work. There are so many examples in here that I believe are really, really helpful, and the examples that they used are actually examples taken from charges filed, and it provides great guidance. So, to the extent that you don't have outside counsel vetting a lot of these issues, the EEOC guidance is a really great resource. The guidance talks about discrimination based on employees' perceived national origin. So this is a little bit different. This is a departure when we talk about perceived, right? Because we know of, when we think of perceived discrimination, oftentimes we think of disability discrimination, right? Where you can't discriminate against somebody because you perceive or believe that they may be disabled. That perceived as really wasn't applied to any other protected category. Basically what the EEOC is saying is that you don't have to have specific knowledge that somebody is from a foreign country, or that somebody is not from the United States, or somebody's accent means that they're not from the U.S. or anything like that. It's perceived. So just based upon the fact that we think that they're from another country. Maybe their skin is this color, or they have a certain resemblance. Even if we think it, it could be the basis of a claim. Because previously we would often argue, as defense counsel, we would argue that, well, we don't know where that person's national origin is from, and if we don't know what their national origin or ethnicity is, then that can't be the basis of a claim. What the EEOC is saying is now, even if you perceive them to be from somewhere else, that could be the basis of a claim. There's a large portion of the proposed guidance dedicated to discussing human trafficking, which is a big issue now. Most employers know that human trafficking, there's huge criminal penalties associated with it. But now the EEOC is basically saying you also have issues under Title VII, and that could be the basis of a claim for somebody who's a victim of human trafficking. Interesting piece for anyone who's a staffing agency, a staffing firm, the guidelines make very clear that staffing agencies are, if you're following the directive of your client that you're not going to direct certain national origin groups or Hispanics or Arabs or to a specific employer, they basically take the position that you are a joint employer, and just because your client tells you or a client has a preference, you still have an obligation under the law not to discriminate against individuals, and under those circumstances, you're a joint employer with the actual employer, and if the employer is discriminating, you too as the staffing agency are discriminating. The new guidance provides that a policy of screening out candidates who lack a social security number implicates Title VII. This is interesting because basically what these guidelines say is that if an applicant comes to you, and I know a lot of companies say, well, if you don't have a social security number, I cannot hire you. These guidelines basically say, and it's consistent with the Department of Homeland Security's interpretation of the guidelines, that if an applicant has, or an employee that you're just onboarding, because you wouldn't know an applicant's social security number, I hope, but if an applicant does not, if a new employee does not have a social security number, but they have applied for one, you have to continue to employ them. You will have to obviously request information or some sort of notification or confirmation that they have applied for the number. But again, you can continue to employ individuals if they're waiting for actual social security number. Of course, the guidelines, and I think this goes without saying, you can't threaten to report an employee's immigration status for participating in protected activity. This came out of a lot of situations where workers were complaining about wage hour violations, and the way that some employers would deal with that is say, you're undocumented and I will call Department of Homeland Security if you bring a claim. So the EEOC enforcement guidance discusses that and addresses that and basically says that that's a form of retaliation. Another interesting thing, and I thought I would spend 1 or 2 minutes focusing on it, is language issues, accents in the workplace. Right. This is, if looking at all of the issues that I think come across, and looking at some of the issues that my clients have raised to me and asked me questions about, I think language issues and English-only issues are probably where HR faces potential exposure to national origin discrimination. Accent discrimination. A lot of times, we have situations where there's an applicant or an employee that has a strong accent. And more often than not, people say, HR is confronted with the issue, well, we can't hire this person because their accent is too strong. The EEOC guidelines has specific examples and really addresses this. And they basically say, listen, unless the accent is so strong that you can't understand the person, you really have to take into consideration having an accent in the workplace is not unlawful, right? Even if you're communicating with customers, basically in order to, not hire somebody for because they have an accent, that person's accent really needs to interfere with their ability to communicate and interfere with, basically create safety issues. Now, they're important to say customer preference is not a reason to not hire somebody or to terminate somebody for having an accent. So again, the example that the EEOC guidelines address is a situation where you have a front desk person at a hotel and the front desk person has an accent. But you could understand through the accent, and a customer who wasn't that nice had a conversation and didn't understand the information that was being provided to him, and complained. And the employer terminated or moved the front desk person to another place, a less desirable position because of the accent. And the EEOC basically said, we can't make these decisions based upon a customer complaint, right, or a customer preference. Just because your customers or clients are saying that they don't want to deal with that person or that they can't understand the accent, so long as everyone else can, as the manager and as HR, you want to check that to see if the person speaks clearly enough so that it's not a safety issue or, a complete lack of communication. So again, we have to be very careful when somebody talks about, that person has a strong accent. I don't necessarily know if they could deal with the public. You really have to closely scrutinize the accent to make sure that it really does impede the person's ability to communicate clearly. The other issue is English-only rules, right? This is probably the question that I get the most. English-only rules are, there's a group of, either Hispanic-speaking or Chinese or some sort of Asian language-speaking employees in the workplace. Most of our staff speaks English, but there's a group of these employees that speak in their own language and they laugh and everyone thinks that they're talking about them. Basically, the position for the EEOC has always been English-only rules are generally unlawful. Basically, prohibiting your employees from speaking any language other than English is unlawful. That's the position that they take. But the EEOC basically said that if you have that situation, and it was great helpful guidance, if you have a situation where other employees are talking in their own language and they're laughing and they're making other people feel uncomfortable, the EEOC basically says you don't have to put in effect an English-only rule, but you can discipline and talk to those employees and explain how their behavior is making other people feel. And they're fine and comfortable with that sort of position as opposed to implementing an English-only rule. So that's sort of a good guidance tip workaround for dealing with these issues, because I think that's where it comes up the most in terms of the workplace. And again, if an employer is going to have an English-only rule, it has to be very specific, very limited, and very tailored to the business situation. So for example, the one English-only policy that the EEOC said was lawful was a situation where you had they had an English-only rule for cleaners who cleaned the operating room. And the English-only policy was limited to, when you're in the operating room and when there's other members of the medical staff there, you have to speak in English so that they can clearly communicate the cleaning requirements. It was a very limited rule. The EEOC said that that was okay. But again, if you're looking at English-only rules, defer to they're unlawful and try other ways around that issue. We're getting towards the end. I just want to briefly go over some practices. The EEOC recommends a couple of things for employers in order to avoid national origin discrimination claims. They talk about use a variety of recruitment methods. Basically, they don't really, the EEOC suggests that you should be advocating and recruiting through all different channels, not just word of mouth, because word of mouth you kind of get a homogeneous applicant pool. They suggest establishing written objective criteria for evaluating candidates for hire. Maybe have a list of questions that you ask everyone so that you're not disproportionately screening out certain protected groups. Develop objective job-related criteria for identifying performance issues. This goes along with every claim of discrimination in every protected category, not just national origin. Implement and distribute an anti-harassment policy. This is an important one, the last one. When languages other than English are spoken in the workplace, ensure that policies are communicated effectively to all employees. If you have a workforce of employees that speak another language and that's their primary language, I strongly recommend at the very least that your anti-harassment policy and discrimination policy be translated into that language. And here is your homework. I've gone over 1 minute, but here's your homework. Your homework is, I would take a look at review pre-employment hiring practices, including interview questions and background check policies to evaluate potential adverse impact. This is important, and it wasn't addressed specifically in the EEOC guidance, but I do recommend that everyone take a look at the pre-employment screening. Pre-employment background checks, including credit checks and criminal background checks. Basically, if you're using bright line blanket rules that say I'm not going to hire anyone that has negative credit or has a criminal conviction, you're disproportionately automatically screening out minority candidates, including individuals in sort of protected categories. So take a look at those policies and practices and make sure that you're complying with, we're in New York, the New York Corrections Law, to avoid adverse impact claims. I said consider translation of employment workplace policies based on the primary language. And take a look if there are any English-only workplace rules. Really take a look at them. If you have any of those rules or policies, take a look at them and take a look at the EEOC guidance on the lawfulness of such policies, because that's really where I see the big hot button issues and the potential claims of discrimination for employers. I thank you all so much. I went over a couple minutes, but I hope that I imparted some knowledge on you. If you would like copies of the slides, please shoot me an email. My information is john.porta, P-O-R-T-A, @jacksonlewis.com, and I could send you the materials. I wish you all a wonderful, safe weekend. It's supposed to be beautiful weather in New York. Everyone should hit the beach. Thank you all so much. Take care.